I'm really delighted to be here. In fact, yes, I was hard pressed, but still, I thought that I should not miss this opportunity. Otherwise, I don't know when I'll be left out. So the first opportunity I just grabbed. Anyway, it's very overwhelming to stand on a platform where, in the past, stalwarts have been the office bearers of the association and the cause, and as the Honorable President has just shared his thoughts. Ultimately, the essence is for both of us, either the bar or the bench, basically to uphold the rule of law and to ensure that the Constitution prevails no matter what. There may be ups and downs, there cannot be a fully level playing platform, but the ability and the endeavor should be to ensure that. I'm sorry I did not address the dignitaries because I thought I would forget this before I come to the formalities. So, Mr. Amarjit Singh Chandiok, President-elect, Mr. Prashant Kumar, President, Dr. Andita Pujari, Vice President, Mr. Amarjit Singh Bedi, Honorary Secretary General, Learned Attorney General for India, Mr. Venkatramani, other office bearers of the Bar Association of India, lawyers, and everybody present here. The Bar Association of India emanated from an idea that was close to the hearts of the constitutional framers, who came from a legal background. The genesis lay in the thought that there should be a unified pan-India bar. After extensive consultations with stalwarts of the bar, the All India Law Conference was held in March 1959, which led to the eventual registration of the association in September 1959, before its formal inauguration in April 60. What makes the Bar Association of India stand out is its unique structure with its governing council comprising members voted in by individual members from all the states and union territories. Senior law officers of the center and states, as also presidents of other national and state bar associations, are ex officio part of the governing council. I am informed that the BAI represents India in international bar organizations, including but not limited to Law Asia, the Commonwealth Lawyers Association, etc. A look into the past also tells us what Mr. M.C. Setalwad, the founding president, envisioned as the association's role and was firm on it, that the association aimed at upholding the Constitution of India. He was of the opinion that the men of law cannot afford to stand aside when the contrary was forging ahead along with its newly chosen path. His earnest hope is best expressed in the following words: to pledge to the smooth and impartial administration of justice and the orderly development of a true democracy. The Rule of Convention 2024 is a tribute to Mr. Fali S. Nariman, who also served this association as its president from 1991 to 2010, as eloquently expressed by Honorable Chief Justice of India in the full court reference of the Supreme Court in his memory about late Mr. Nariman. It could be said, no matter the client, the government or the case, Mr. Nariman sought to advance a vision of the law grounded in liberty, equality and justice, the foundational values of our Constitution and ultimately our society. No matter the occasion or the opponent, he conducted himself with grace and poise. When many voices fell silent during difficult times, Nariman's resounding baritone resonated in the vaults of the court and beyond. His voice represented the consciousness of the nation. On the issue of the rule of law, it is an appropriate occasion for the women and men of law to rededicate ourselves to following his legacy, not in service for self but for service of the nation. The convention also seeks to explore and examine the impact of Bharatiya Nyaya Sanhita 2023, Bharatiya Nagarik Suraksha Sanhita 2023 and Bharatiya Sakshya Adhiniyam 2023 on lawyers and citizens. As you are aware, these laws will take effect from 1st of July 2024 and replace the Indian Penal Code 1860, the Code of Criminal Procedure 1973, and the Indian Evidence Act 1872. Lawyers will be aware of what they need first and foremost. On a lighter note, a chart or a table comparing the older and newer provisions to find out which sections in the new statutes mirror which sections of the old statutes. That apart, I am sure the two-day convention would brainstorm on the issue. I think it would be best for me to avoid detailed comments on the new set of laws at the present juncture, as legal challenges on merits may come up before the court after they come into force, which could require adjudication. Coming back to the rule of law, it is noteworthy that the framers of the Constitution had before them various types of administrative, political and justice delivery systems to choose from. Broadly speaking, in terms of extremes, you had a rule of law system, somewhat rudimentary, but which did give the individual a few basic rights, and on the other hand, you had a rule by law system which gave the state an upper hand in most spheres of a citizen's life and reduced the citizen to a mere appendage in the machinery of the state. One of the unfair criticisms mounted against the Indian Constitution is that it borrows from many other constitutions and systems. I believe this is unmerited. After all, why should a nation learn only from its own mistakes? If other countries have tried and tested out various kinds of institutional mechanisms which have served them well, what is the harm in adopting them? Rather, it is a testament to the wisdom and sagacity of the Constituent Assembly that our Constitution is what it is and is functional even today. If you look around the world, or for that matter even around the subcontinent, our Constitution is not too old, yet our Constitution stands out as a shining example. As the late Dr. B.R. Ambedkar, chairman of the drafting committee, had once pointed out, however good a constitution may be, if those who are implementing it are not good, it will prove to be bad. However bad a constitution may be, if those implementing it are good, it will prove to be good. I must make mention of the fact, and as some of you may already know, our criminal justice delivery system is facing challenges. A number of persons lost in jails are not convicts, they are merely under trials. Another chunk of people in jail are those who have been convicted, but their appeals against conviction are still pending in the respective high courts. It would not be out of place to refer to the fundamental credo which lies at the heart of our Constitution, that is, the principle of innocent till proven guilty. Of course, except for the special statutes that reverse the burden of guilt onto the accused. The United States Supreme Court long ago had put the principle succinctly as being the undoubted law, axiomatic and elementary, and its enforcement lies at the foundation of administration of a criminal system. It was in the case of Coffin versus United States. The Supreme Court of ours has repeatedly settled this principle of law multiple times, including as recently as in the judgment rendered in the matter of Suresh Chamappa Shetty versus State of Maharashtra in the year 2023. We are at a crucial crossroads in our national history, but to truly fulfill our tryst with destiny, we will need to yet again remind ourselves of the Mahatma's promise and goal: to wipe away every tear from every eye. To the ordinary person on the street, it matters little what law you govern him with. I am being extremely frank. She or he is not concerned in her or his mind about the specifics of the law. He or she is more concerned with a different question. Will the law, whatever it may be applied fairly to me? Will the authority treat me fairly? Will I get a fair trial? Will principles of natural justice be followed? We also need to tell our judges in the districts to not hesitate to grant bail in a deserving case. The high courts have to tell them that they will not be targeted for granting bails in appropriate cases. The Supreme Court and the High Court cannot and will not hesitate to step in when needed, but if bail is granted below in a lot of cases, it would obviate the need for people to knock doors of higher courts besides reducing the time spent in jail pending trial. While our economic metrics improve, we should not lose sight of the ground realities. Most of those in jail come from extremely disadvantaged backgrounds, judged from any socio-economic sphere of poverty, of gender, of religion, of caste. That woman or man is more directly affected by a daily fear of unfair treatment. This is exactly what a robust system based and premised on a rule of law aims to prevent. Illustratively speaking, whether you look at the old set of statutes or the newer ones, what doesn't change is the Constitution. The rights guaranteed under Part 3, more particularly under Articles 14, 15, 19, 20, 21 and 22 in the context of penal statutes are the bulwark standing between the ordinary citizen and the mighty state. These articles will always operate to protect the citizen, but lawyers and judges have an important role to play herein. Apart from the obvious text of Article 21 in Menka Gandhi versus Union of India, it was imported formally into our Constitution the due process of law, which is fair and reasonable. The faith of the public in the rule of law must be maintained. One of the obvious facets of the rule of law is the independence of the judiciary. A judiciary which will look out for the citizens, a judiciary which will balance the competing rights of the individuals and the state. While one side holds the life and liberty of an individual, the other side has the interest of society and state. Edmund Burke once had occasion to comment that greater the power, more dangerous the abuse. Some years back, late Mr. Nariman had said that the citadel never falls except from within. It is time for the women and men of law to pay heed to his ideals and thoughts. I wish the convention all success and thank the Bar Association for giving me this opportunity to be part of the inaugural session. Thank you. Jai Hind.